the most interesting element of the Hunter Biden indictment. In one sense, the Hunter Biden indictment just isn't that remarkable, or interesting. Aside from the fact that it's brought against the president's son, it's just plain vanilla gun charges, and the prosecution seems to have him dead to rights. He lied on Form 4473, the federal form he was required to fill out when he purchased the weapon in question, by certifying that he was not illegally using drugs. He has since publicly stated that he was regularly using drugs, including crack cocaine, when he bought the gun. Thus, there's overwhelming evidence he committed two related crimes, lying on the form and possessing the weapon itself. Federal law prohibits unlawful users of controlled substances from possessing firearms. But these are not ordinary times, and in another sense, the Hunter Biden case is very interesting indeed. Ironically enough, it could ultimately end up undermining a key element of federal gun regulations. The case could be so threatening to federal gun control efforts that in less polarized times many Republicans would be supporting at least one element of Biden's likely defense, that the prohibition against unlawful drug users owning guns is unconstitutional, at least as applied to him. Some background is necessary. In 2008, the Supreme Court decided the case District of Columbia v. Heller, which established that the Constitution guaranteed an individual right to possess a weapon in your home, apart from any service in an organized militia. But the decision raised as many questions as it answered. Which precise types of firearms were covered by the Second Amendment? Which forms of government gun control regulations remained viable? And, critically, what kind of constitutional test should courts apply to gun control regulations after Heller? The last question arguably mattered the most. But the Heller decision did not establish a test. Instead, it spoke of the right of law-abiding, responsible citizens to use arms in defense of hearth and home. It noted that the amendment protected the kinds of weapons that are ordinarily used for a traditionally lawful purpose. And it took pains to say that nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. The case kicked off years of additional litigation, and in the absence of clear guidance from the Supreme Court, lower courts established their own tests for firearms regulations, largely applying a form of intermediate scrutiny that left intact a wide range of gun control measures, including bans on so-called assault weapons and large-capacity magazines. It left untouched the standard prohibitions against weapons possession, including by unlawful drug users. Then, in 2022, the Supreme Court dropped a nuclear bomb on state gun regulations. In New York State Rifle v. Pistol Association Incorporated v. Bruin, the court did two things. First, it established that the Second Amendment didn't just establish a right to keep a gun in the home for self-defense, it also established a right to bear a gun outside the home. The right to bear arms outside the home wasn't unlimited, however, which brings us to Bruin's second, and most important, holding. In his majority opinion, Justice Clarence Thomas established a new constitutional test for gun regulations. Rather than applying conventional legal tests for constitutional rights, such as subjecting gun regulations to intermediate or even strict scrutiny, those regulations now have to be evaluated using the text and history of the Second Amendment. Put in plain English, that means that modern gun control measures can be sustained only if the government can point to historical analogs, with an emphasis on those existing at the time the Second Amendment was adopted or when the 14th Amendment, which made the Second Amendment applicable to the states, was ratified. The result, quite simply, has been legal chaos. The history of gun regulation is not so neat and clean as to yield easy historical parallels to the questions at issue today. American legal doctrine has developed considerably since the colonial and Reconstruction eras. As a result, unless the government can draw a bright line between history and the present day, its gun control measures are in mortal legal peril. The federal court rulings after Bruin have been dramatic. In United States v. Rahimi, the Fifth Circuit reversed the federal conviction of a man who possessed a weapon while subject to a domestic violence restraining order. In April, a federal district judge struck down the gun possession charges of a marijuana user. In June, the Court of Appeals for the Third Circuit, sitting en banc, held that federal law violated the Second Amendment rights of a nonviolent criminal to purchase a firearm. And now Hunter Biden, who bought a gun as a nonviolent, unlawful drug user, is charged under the same federal statute at issue in each of the cases above. Arguably, Biden's best defense to that charge is to join a host of other criminal defendants by challenging that count under Bruin's text and history test. He just might win, and if he does, he will contribute to the dismantling of a key element of federal gun regulations. My own view is that Thomas' text and history test is deeply misguided. To take the Rahimi case as an example, American legal history is frankly dismal when it comes to protecting women from domestic violence. Should this long-standing historical failure have the power to determine modern legal doctrine? Similarly, prohibitions on drug use and possession largely date to the 20th century. Modern gun jurisprudence should not restore our nation's laws to a deeply flawed, pre-modern phase. Earlier this year, the Supreme Court granted the federal government's motion to hear the Rahimi case, and oral arguments are set for November 7. The court has an opportunity to right the wrongs of the worst aspects of its holding in Bruin. But unless it does, there may be few greater beneficiaries of a conservative legal doctrine than Hunter Biden himself. His ordinary gun charge landed in a time of legal chaos over gun regulation, and unless the Supreme Court says otherwise, expect that chaos to win. The most interesting element of the Hunter Biden indictment. In one sense, the Hunter Biden indictment just isn't that remarkable, or interesting. Aside from the fact that it's brought against the president's son, it's just plain vanilla gun charges, and the prosecution seems to have him dead to rights. He lied on Form 4473, the federal form he was required to fill out when he purchased the weapon in question, by certifying that he was not. The articulate ignorance of Vivek Ramaswamy. As our nation continues its march to 2024, a year that will feature not only a presidential election but also potentially for criminal trials of the Republican frontrunner, I've been thinking about the political and cultural power of leadership. How much do leaders matter, really? What role does corrupt political leadership play in degrading not just a government but the culture itself? Let's talk today about the specific way in which poor leadership transforms civic ignorance from a problem into a crisis that can have catastrophic effects on the nation and, ultimately, the world. Civic ignorance is a very old American problem. If you spend 5 seconds researching what Americans know about their own history and their own government, you'll uncover an avalanche of troubling research, much of it dating back decades. As Samuel Goldman detailed 2 years ago, as far back as 1943, 77% of Americans knew essentially nothing about the Bill of Rights, and in 1952 only 19% could name the 3 branches of government. That number rose to a still dispiriting 38% in 2011, a year in which almost twice as many Americans knew that Randy Jackson was a judge on American Idol as knew that John Roberts was the Chief Justice of the United States. A 2018 survey found that most Americans couldn't pass the U.S. citizenship test. Among other failings, most respondents couldn't identify which nations the United States fought in World War II and didn't know how many justices sat on the Supreme Court. Civic ignorance isn't confined to U.S. history or the Constitution. Voters are also wildly ignorant